This is an NBC News special report. Here's Hallie Jackson.
Good morning. We are coming on the air with breaking news about President-elect Donald Trump and this morning's sentencing in his hush money case. At a hearing just moments ago in Manhattan Supreme Court, New York Judge Juan Merchan issued his decision. The sentence, unconditional discharge, covering all 34 counts. Here's what that means. No prison time, no fine. As expected, this is the most lenient sentence possible. Mr. Trump was not there in person, but he did appear virtually on a live stream into the court just before the sentence was handed down, calling this, in his words, a very terrible experience. The proceedings were not on camera, but there is audio. You are looking at a still image from inside the courtroom. We do expect to see the audio released later on this morning. Remember, Mr. Trump was convicted last May on 34 felony counts of falsifying business records in what prosecutors said was an attempt to cover up a $130,000 hush money payment to adult film actress Stormy Daniels. Again, this morning, Mr. Trump has denied any wrongdoing. And now, a milestone, one that makes history. The president-elect is now officially a convicted felon 10 days before his inauguration. Let's get right to NBC News senior legal correspondent Laura Jarrett. So, Laura, explain Judge Merchan's reasoning here and what it means for the president-elect.
Hallie, another historic first for Donald Trump, now a free man, but a convicted felon. The judge just making it official minutes ago, explaining the reasoning for this is not that the facts have changed, not that the law has changed, but his status has changed. Now as the president-elect, as you say, just 10 days from being sworn into office, he decided that he could not give him any prison time here. He was facing up to 4 years in prison. And, Hallie, that was always a long shot, given that these were low-level felonies. But the judge made clear, given all the facts and circumstances here, prison was not on the table. He acknowledged it was an unusual circumstance that he had previewed that sentence ahead of time. But he also acknowledged all the ways in which, when the doors closed to that courtroom, this was an ordinary case. There were opening statements, the jury deliberated, and they reached a verdict. The prosecutors spent a lot of time walking through what they called Mr. Trump's attacks on the rule of law, while we heard for the first time from the president-elect himself, speaking there virtually from Mar-a-Lago, calling it a terrible setback for the state of New York. Hallie.
Laura Jarrett, thank you very much. This concludes our NBC News special report. Stay with us. We'll have continuing coverage on our streaming channel, NBC News Now. For most of you, we'll send you back to the Today Show. I'm Hallie Jackson. For all of us here at NBC, thanks for watching. Good morning, I'm Hallie Jackson, and we are back on the air with this NBC News special report. The sentencing for President-elect Donald Trump in that New York hush money case, unconditional discharge on all 34 counts. This was just handed down from the judge moments ago. What does this mean? No prison time for the president-elect, as expected. No fine. It is the most lenient sentence possible. Let me bring in now our NBC News senior legal correspondent, Laura Jarrett, who's been watching all this. Laura, we've talked through here the implications now for the president-elect. Judge Merchan pointedly made a distinction between the office of the president and the individual occupant of that office as well.
I think he was trying to make that distinction because he recognizes the unusual circumstance he's been put in. He said, look, I've been sentencing many defendants, hundreds of defendants all the time from any different range of circumstances, and I've never faced a situation like this, which is part of why I think he gave a preview of what this sentence would be, something you never see. But the judge, I think, recognized that there was so much attention around this and such an unusual circumstance with him just set to be sworn in 10 days from now that he wanted to lay his cards out on the table for everybody and do this unconditional discharge. And just, it sounds like legalese, but so people understand here, it means his release without any conditions, no penalty, no fine, no home confinement once he's out of office. This is done. Now, can he appeal the actual conviction? Because right now, that conviction is on his record, so to speak. He can, and his lawyers have indicated that he will. But in reality, Hallie, what he wanted to do was avoid what has just happened. He wanted to avoid that conviction being on his record. He wanted to avoid going through with this whole sentencing. He went all the way up to the U.S. Supreme Court to try to get it stopped. They refused to step in late last night. And so now he is, in fact, a convicted felon, Hallie.
It's worth reminding people, Laura, he can't pardon himself in this instance.
He cannot. That has never been done before. It would be unprecedented again. The Supreme Court would probably have to get a look at it, although it'd be hard to know who would have standing to challenge it. I think at this point, it's fair to say that this conviction is going to stand, at least for a long time, because even the litigation over it, how is he going to do that while also serving as the president? And just so people understand, the challenge there was that the jury was infected. The trial was infected by evidence that should not have come in, that things the Supreme Court said should be protected by presidential immunity. Again, no court has ever looked at this before. Judge Juan Merchan said that this has never happened before. And so Judge Juan Merchan said he is not immune. Nobody else has had the opportunity to weigh in on that, not even the Court of Appeals in New York. And so if he chooses to go forward with that appeal, the usual remedy, if something went wrong at trial, is to get a new trial. But of course, he doesn't want that either. And so for all intents and purposes, Hallie, this case is over.
Laura, stand by for a moment. Let me bring in Garrett Haake, who covers the president-elect for us. Garrett, I want to let folks know what we're expecting here. This just wrapped literally minutes ago. That is why we're on the air with breaking news. At some point this morning, we do expect to hear the audio proceedings here. No cameras were allowed in court, but we have been showing a couple of pictures to people, a couple of these still images, because you're seeing this here. This is the live stream. Obviously, President-elect Trump and his attorney, as they appeared virtually. There's one other photograph from inside the courtroom as well. Those are the only images we're getting. But we will hear this all play out. And when we do, Garrett, we will hear President-elect Trump speak because he had the opportunity to do so. He did. And as he has done in the past, he railed against this hush money case.
Yeah, that's right, Hallie. The president-elect's comments here would sound familiar to anyone who attended any of his rallies during the presidential campaign. He described this as a political prosecution against him designed to hurt him in the political campaign that has just concluded. Of course, it ended up having the opposite effect, at least in the Republican primaries, where it forced a sort of consolidation of Republicans around him. But nevertheless, the president-elect attacking prosecutors, suggesting it was the Department of Justice out to get him, out to weaken him along the way. He was more careful in his comments about the judge, although in the past he's been very critical of Judge Merchan, really kind of getting his feelings about this case off his chest for one last time, although I doubt we've heard the last from him on this topic. His attorney was much more circumspect, a little bit more careful in his remarks right before that, Todd Blanche, arguing that, the prosecutor's characterization of this case as just the normal carriage of justice in New York City is out of bounds, that this was a political prosecution. But it was Trump who has carried that line of attack and turned the case into a political rallying cry for his campaign, and now perhaps even in the early days of his second presidency, Hallie.
We talked a bit, and we'll get to Danny Savalos in just a second, our legal analyst here, Garrett, about the potential for an appeal here. And the president-elect has suggested he wants to appeal, I'm quoting him here, psychologically. Do we have any indication of what he means by that?
Candidly, Hallie, we do not. It is very much unclear what he means by that. But I think it goes to the point that Laura was just making, which is there's very little he can do here legally, but I think he will continue to fight the fight that he has done publicly here to say that this should never have happened. The crimes weren't real crimes. He believes he's an innocent man. He, in his remarks today, suggested that any mistakes here were done by others, by accountants, and not by him, and that he will try to clear his name in the public sphere, even if he can't do it in the legal one.
Garrett, I'm going to ask you to stand by. I know it is very cold there in New York, but if you don't mind indulging me for just a moment, because I want to get to Danny Savalos briefly, our NBC News legal analyst. Danny, this was not an unexpected decision from Judge Merchan. He had, in some ways, signaled that this is what he would do today.
He directly signaled exactly what the sentence would be, and I can't tell you how unusual that is. In the federal and state system, almost every time defense attorney and the prosecution and the client go into sentencing not knowing for sure what they're going to get. Now, a lot of folks say, well, when you enter into a plea agreement, you have a pretty good idea. Yes and no. First of all, this was not a plea agreement, so there was no meeting of the minds. But secondly, the judge always has the final say, and he tells the defendant that. You may have entered into an agreement, but I have the final say. And no, I've never heard of a criminal defense attorney or a prosecutor calling up chambers and saying, hey, can you give me an idea of what the defendant's going to get before we get there? And yet, Justice Merchan did exactly that and acknowledged that it was highly unusual in his opinion. So here, everyone came in, no surprises, although the law requires him to put his reasoning on the record, which he presumably did. However, this was an unconditional discharge, which, by the way, a lot of talk about this being a non-jail sentence. That's only half the story. It's a sentence of nothing. No probation, no community service, no house arrest, no reporting, no nothing. It is a sentence of 0.0 anything.
Well, so that brings me to this question of implications then for Donald Trump, for the president-elect, because you're right. No house arrest, no probation, no fine, nada. There was never, it was, I think, not expected that he would ever face prison time for charges like this. But when you talk about the implications here, Danny, he will be known. I mean, he is now a convicted felon officially, and that is a moment that is making history here in this country.
That's right. And we should talk a little about what exactly you mean, because in the criminal system, yes, someone gets convicted after a jury verdict, but technically, under the rules of procedure, it's not considered a final judgment until the sentence, and then the judge takes that and then he now uploads it to the system, but enters it on the system. Then it becomes final. Now the 30-day clock starts ticking in which to file the notice of appeal. And that is the direct appeal, the appeal every defendant has as of right to the appellate division. It won't feel that way because the Trump defense team has appealed tons of things in this case. As we sit here today, the case itself is technically on appeal to some degree in every court, including arguably the Supreme Court, although it's not a direct appeal. But now the true appeal process begins to the appellate division, and the case could conceivably last all through those 4 years of Trump's term while on appeal, although I think it's unlikely. This is going to be a priority.
Handicap those chances, then, on this appeal.
Well, look, it's tough to handicap any Trump cases because a lot of that appeal is going to deal with brand new case law from the Supreme Court in July of 2024. So we don't really know exactly what these issues of law, where they will arrive, and what court ultimately this appeal will arrive at. Although a safe bet might be if the defense can do it, they will get it into the U.S. Supreme Court.
Laura, let me go back to you on that. And this is a Supreme Court that we saw a decision from last night that allowed this sentencing to move forward that was in some ways somewhat surprising given the makeup of the decision, right? The justices who sided with the liberals on the court.
Well, and it was close, Hallie. At least 4 of the justices were willing to issue a stay, which means this sentencing that just happened minutes ago would not have happened. 4 of the justices were willing to say, let's pause this, let's slow things down. Now, they didn't ultimately prevail, but I think it is noteworthy that this was actually a close call for some members of the court. Now, maybe it could have just been that they felt rushed and the timing and all of that went into it. We don't know exactly all the behind-the-scenes machinations. We do know, according to the brief order that we got from the court, that at least the majority of the justices felt like the fact that he wasn't going to get jail time was meaningful, and so he wasn't as prejudiced. And the fact that he can still do the appeal that Danny just walked through, as much of a long shot as it is, for those 2 reasons, they weren't willing to step in, and they were they ultimately did allow this sentencing to proceed today. But they clearly it clearly wasn't a slam dunk for them.
We are showing some of those images now from inside that Manhattan courtroom where these proceedings happened. And I just want to remind folks, any minute we expect to see, at least momentarily, audio from this sentencing to be released. No cameras in court, but we will hear what went down. And by that, I mean we will hear what the prosecutors had to say, what the president-elect's defense team had to say, and then, of course, that sentence from Judge Merchan himself, in addition to President-elect Trump's remarks as well. I want to go back to Garrett Haake, who's standing by for us now outside court, and I want to let folks know we will play that audio the second that we get it. So you will get a chance, everybody will get a chance to hear what unfolded inside court. But, Garrett, one of the things that we heard from President-elect Trump that he has talked about repeatedly for many months on the campaign trail is this idea that he feels like he was politically persecuted in this case. And that is an argument that seemed to resonate with some of the people who voted him into the White House.
Yeah, that's right. He made the argument that if his name were Donald Smith, he would never have been targeted in this way. That was not the verbatim argument from today, but this is the way that he has described this case really from its inception, pointing out that previous DAs, other law enforcement entities had looked at the same facts and chosen not to pursue cases against him. It was only after he became a political candidate again that this case got new life. As I mentioned earlier, if that was the theory, it certainly backfired in in the Republican primaries, where Republican voters did, in fact, rally around Donald Trump, infused his campaign with energy and with money in the early stages of the primaries that helped him put his opponents behind him. He has used that attention and that energy throughout his campaign, and Hallie, he is using it even today, just moments after the sentencing concluded his political operation, sending out a fundraising appeal asking for folks to email and donate to send their thoughts and their money. So he has used the idea that he is somehow, if you will, such a powerful enemy of the left, of President Biden and of Democrats. This is the mechanism that they have been forced to use to defeat him. He calls it lawfare, and it has become a point of understood fact among many on the right that this is an attack on this president, now president-elect, and that he has had to defend himself in the manner that has led to him being gagged in this case, and then ultimately at one point held in contempt for violating that gag order all along the way, as he has felt necessary to defend himself publicly from a political case as he sees it.
Garrett, thank you. Laura, Jarrett, let me go back to you on this, and let me just sort of remind people, because we've talked a lot over the course of the last several years about the web of legal issues that Donald Trump has faced. Most of it was federal. That essentially goes away once he's inaugurated into the White House. We knew that was coming once he won the election in November. There still is a chance that we may see a report from Jack Smith, right? Explain that piece of it and where that may go.
Yeah, if you think about sort of the puzzle, the web of legal issues that are still outstanding here, there was a Georgia case about election interference. That case has died on the vine because a court has found that the DA that brought it was ethically conflicted. So put that one aside. This one's now done because of the sentencing. There are the two federal cases which the special counsel, Jack Smith, has already moved to withdraw. So the cases against Donald Trump don't exist anymore. But under the special counsel regulations, he's supposed to detail his findings for the Attorney General. And the Attorney General, Merrick Garland, has indicated he intends to make those public. The issue here, Hallie, is that, remember, in those two federal cases, in one, he's by himself. In the Washington, D.C. case, that's about the attempted coup in 2020. On the classified documents case, he has two co-defendants. Why does that complicate things? Because the case is still active technically against those co-defendants. And as long as there's an active case, the Attorney General, the Justice Department has a policy, really a rule, of not putting out any damning information. And so what are they supposed to do when they have that active case in Florida? And so as of right now, the Attorney General expects to release the report, at least as it relates to the election interference materials. And we could see that as soon as today, Hallie. The Justice Department is fighting that out in court right now in the 11th Circuit, trying to make sure that they can lawfully release that. But as it relates to the classified documents case, we may not see that report for some time. And so it remains to be seen. It's sort of a messy circumstance. And you might say, well, if the case is dismissed against Donald Trump, then who cares about the report? But the report could actually be quite interesting, because in that case, Jack Smith can explain why he brought certain charges and why he didn't bring certain charges. And it might provide a little bit more detail, a little bit more color about certain aspects of his thinking, most of which we have never heard before.
And you say that report could be released as soon as today. It's got to be released by the 20th.
Certainly, because by the time the 20th rolls around, Jack Smith will be no more, and that report will be gone.
Laura, Jarrett, thank you. Danny Savalos, let me go back to you and just reminding folks here, we have seen this go down in that courtroom in Manhattan, this sentencing, this historic sentencing for President-elect Donald Trump within the last 45 minutes. We are now waiting to see the audio, or to hear the audio from inside court. No cameras allowed, but they are going to play out the entirety of the proceedings here. So the prosecutor, the defense attorney, the president-elect, Judge Merchan himself delivering this sentence. When we talk about this sentence, unconditional discharge, not unexpected. There had been a gag order in place against President-elect Trump. We saw that on the campaign trail. It raised some questions in the eyes of those close to the president-elect about free speech and political expression at a time when he was running for office. Does that gag order now go away now that the sentence has been dropped?
Yeah,
or delivered, I should say.
Right. Back before Justice Merchan announced the sentence that Trump was likely to get, there were folks who thought that one of the factors that could weigh in favor of a sentence of incarceration was the gag order and the repeated attempted violations of that gag order. That, of course, once Merchan announced that it would not be a sentence of incarceration in any way, that was no longer a factor. But presumably, once we get the audio, I expect that Justice Merchan will say something about the gag order because there's no need for it going forward. The case is now leaving Supreme Court, which is New York's lowest trial court. It is leaving that court and moving up to the appellate division with the certain appeal that Trump will file within the next 30 days. So likely, I would expect Justice Merchan got rid of the gag order. Arguably, it wasn't necessary after the verdict, but this is a very unusual case. I mean, we're talking about a case in which a judge announces the sentence beforehand. The defendant can appear at sentencing by video conferencing, also incredibly rare. So why not? Why not have something else unbelievably rare, which is continuing a gag order, which themselves, by the way, are very rare for the reasons you just described. They implicate the First Amendment and are almost always a possible violation of the First Amendment. So courts don't really like granting them. I would expect the gag order has gone, but if no one mentioned it, in theory, I guess it still exists, but not really.
We'll find out more on that, Danny. Thank you very much. Garrett Hake, let me go back to you, because in the moments before Judge Merchan delivered the sentence, we heard from President-elect Trump. Now, in the moments after that sentence has come down, we are hearing from him again, I believe, on his social media platform.
That's right, Hallie. The president-elect turning to his favorite megaphone, Truth Social, to give his first reaction to the sentencing here. And if he's bound by a gag order, he doesn't seem particularly concerned by it here. In this lengthy post, he calls his sentencing today a despicable charade and says that he will appeal it. He goes on at some length to attack as a witch hunt, as un-American, and talks about the idea that he got this unconditional discharge. He says that result proves in his mind that there never was a case here at all. So a distilled version of the 6 minutes of remarks that we got from a more restrained president-elect in the courtroom today, or in the courtroom virtually, again, distilled down here, where he says the American people saw that this case had no crime, no damages, no proof, no facts, no law, only a conflicted judge and a star witness who was disbarred, disgraced, and a serial perjurer, referring there to Michael Cohen. So again, I don't think we have heard the last for the president-elect, but he is venting his true feelings about it quite clearly here on social media.
And Laura, Jarrett, just to be clear, an unconditional discharge does not mean this case is wiped away entirely.
No, it doesn't. But it sort of gets out from underneath the real rub of why the defense attorneys said that this sentence should go away, right? Because if theoretically he could have been sentenced to jail, that would be a remarkable thing, 10 days out before he's set to be sworn in as the next president of the United States. And so their whole argument is, while the judge floated the possibility that he wouldn't get any jail time, they didn't know for sure. That was part of their argument for why they needed to go to the Supreme Court to get this whole thing called off. And so the unconditional discharge basically means there's no conditions on his release, meaning there's nothing that he's going to face in the future, no penalty or anything like that. But the case does still technically exist, so to speak. Hallie.
Laura, that audio is about to play out momentarily from the proceedings today. Help people understand what we're about to hear.
Yeah, I have to underscore, this part is quite unusual. Different state courts around the country do things differently, and sometimes you never see anything. Sometimes the entire thing is on video. In this case, Judge Juan Merchan opted not to make this case public on video, either audio or video feed, the entire trial. We have never seen anything like this. So this is the first time we're going to actually hear the president-elect speak in court. This is the first time we're going to hear the judge. Now, again, it's just the audio, but it is still a moment to underscore here, because throughout the entire proceedings, including the actual verdict itself, all of that was behind closed doors, and we only were able to rely on our team there, which was feeding us terrific notes. But this is the first time we'll actually be able to get a flavor of the tone and the tenor of the judge's remarks, and of course also from Donald Trump as well, Hallie.
It's about 30 to 40 minutes or so, the entirety of the proceedings, because, Laura, there was an opportunity for the prosecution and for the defense to speak before Judge Merchan delivered his sentence, which, by the way, came in the last 90 seconds of the proceedings today.
Yeah, which is pretty typical in almost all proceedings. You see the judge giving everybody an opportunity to have their last say. And, of course, the defendant is always able to make remarks in what's known as an allocution, which in this case, as Garrett said, the president-elect sort of gave it what you would think of as sort of his campaign-style freewheeling riff, which many of us who cover the trial are familiar with, which he did outside of the courtroom. And he sort of did a version of that in his in-court statements there, even though he appeared virtually.
Laura Jarrett, thank you very much. We're going to take you now to the audio proceedings from the historic sentencing of President-elect Donald Trump. Let's listen.
Good morning. People, ADA's Joshua Steinglass, Christopher Conroy, Susan Hoffinger, Becky Mangold, Matthew Colangelo, and Catherine Ellis. Good morning, people.
Eamon Bowley for President Trump, hearing from your teams. He's co-located with my partner, Tom Blanche.
All right, good morning, Ms. Bowley. Good morning, Mr. Blanche. Good morning, Mr. Trump.
Good morning.
Although Mr. Bowley has already alluded to it, just for the record, I want to make clear that Mr. Blanche is appearing virtually with Mr. Trump. And you're currently in Florida, is that correct?
Yes, that's correct, Your Honor.
Okay. Mr. Trump's other attorney, Mr. Bowley, is with us in the courtroom. Pursuant to this court's decision and order dated January 3rd, 2025, Mr. Trump was given the option of appearing virtually. And subsequently, counsel for Mr. Trump informed this court that Mr. Trump had elected to waive personal appearance and appear virtually. Decision of sentence in this matter is permitted in New York, and I direct your attention to the matter of People v. Reyes, 72 Miscellaneous 3rd, 1133, 2021. Before turning to the matter of sentencing, I want to confirm that the people and defense counsel have both received copies of the probation report. You have not? All right, let the record reflect that the people are being handed a copy now. Mr. Bowley's being handed a copy. Why don't you take some time to look at it, okay? Thank you. While the parties look at the probation report, Mr. Blanche, I'd like to confirm that you received an e-copy of the report.
Yes, Your Honor. We received a copy this morning, and I have it in front of me.
Is there anything about that report that you would like to put on the record?
Nothing other than the fact that it was that some of the facts and procedural history, especially involving other cases, are not up to date because of what's happened since the date of the report. But otherwise, given what we expect is happening today, nothing.
Okay, thank you.
So just so you know why there's a pause in the proceedings here, the judge is giving an opportunity to both sets of attorneys to take a look at a report that was handed out, a pre-sentence report. So that is why you are hearing this moment as the prosecution and the defense are taking a look at it. It is not anything wrong with your television or your audio. We'll go back and listen in.
No, Judge, I'm just needed a couple more time. Sure, don't mind.
While we wait for this pause to finish, Danny Savalos, you're with us now. One of the things people are hearing is the prosecution is going to recommend also a sentence of unconditional discharge. Why would the prosecution recommend that as well?
Because I suspect the prosecution knows it's the only workable sentence in this situation. Consider this. What if the prosecution asked for probation? That would obviously not be completed in 10 days or 7 days. It would take months and months. And now you get into Trump's presidency, and the prosecution knows there's a very strong argument for the fact that a state court couldn't possibly put a sitting president on probation. It couldn't require him to pick up the phone and call his probation officer or wear a tether or do community service. None of those things. I don't know if we're back in.
We are, yeah. Thank you very much. We'll listen back in.
Donald Trump, before the court for sentence, following the conviction by trial to 34 counts of falsifying business records in the first degree. Before being sentenced, the court will allow you, your attorney, and the assistant district attorney an opportunity to address the court with any matters relevant to sentencing. For the people.
Thank you. Judge, where's the preferred place for me to stand?
Wherever you feel comfortable.
The defendant in this case, as you know, stands convicted of 34 counts of falsifying business records in the first degree, all Class E felonies. Each carries a range of authorized sentencing options. An inclination to impose an unconditional discharge. Under all the circumstances of this case, its unique posture and the defendant's status as president-elect, the people recommend a sentence of an unconditional discharge. In finding the defendant guilty in this case, the jury necessarily found unanimously that the defendant falsified 34 separate entries in his business records with the intent to defraud, which included an intent to commit or conceal a conspiracy to promote his own election by unlawful means. Having presided over the trial, Your Honor is very familiar with the conduct, its seriousness, and the overwhelming evidence to support the jury's verdict. I'm certainly not going to rehash that now. In last week's decision on January 3rd, this court referred to the gravamen of the defendant's conduct, his criminal conduct in this case, as constituting, quote, premeditated and continuous deception. The verdict was delivered by a jury that was carefully chosen using an extensive questionnaire based on suggestions from both parties and after thorough questioning of the prospective jurors by both sides. The verdict in this case was unanimous and decisive, and it must be respected. As this court has observed, quote, the sanctity of a jury verdict and the deference that must be accorded to it is a bedrock principle in our nation's jurisprudence. The defendant's conduct before, during, and after this trial also merits consideration. Instead of preserving, protecting, and defending our constitutionally established system of criminal justice, the defendant, the once and future President of the United States, has engaged in a coordinated campaign to undermine its legitimacy. Far from expressing any kind of remorse for his criminal conduct, the defendant has purposefully bred disdain for our judicial institutions and the rule of law. And he's done this to serve his own ends and to encourage others to reject the jury verdict that he finds so distasteful. He has characterized these proceedings as corrupt, rigged, a witch hunt, or a sham too many times to tabulate. The defendant's rhetoric has only ratcheted up since this court's rulings on his motions to dismiss. He has been unrelenting in his unsubstantiated attacks upon this court and its family, individual prosecutors and their families, the witnesses, the grand jury, the trial jury, and the justice system as a whole. The defendant has not only been held in contempt by other jurists in other matters, but this court alone found the defendant in contempt for 10 distinct violations of the order restricting extrajudicial speech. In his legal filings, the defendant has used dangerous rhetoric in leveling accusations of intentionally unlawful and unconstitutional conduct on the part of this court and the prosecution. As this court has noted, the defendant's conduct, quote, constitutes a direct attack on the rule of law itself. Moreover, the defendant has publicly threatened to retaliate against the prosecutors who have sought to hold him accountable in this and other matters, and the courts who have endeavored to fairly and faithfully adjudicate these matters. Such threats are designed to have a chilling effect, to intimidate those who have the responsibility to enforce our laws, in the hopes that they will ignore the defendant's transgressions because they fear that he is simply too powerful to be subjected to the same rule of law as the rest of us. In his 2024 end-of-year report, United States Supreme Court Chief Justice Roberts warned of the dangers of such conduct. Quote, public officials, too, regrettably, have engaged in recent attempts to intimidate judges. For example, suggesting political bias in the judge's adverse rulings without credible basis for such allegations, end quote. Chief Justice Roberts continued, quote, attempts to intimidate judges for their rulings are inappropriate and should be vigorously opposed. Public officials certainly have a right to criticize the work of the judiciary, but they should be mindful that intemperance in their statements when it comes to judges may prompt dangerous reactions by others. Chief Justice Roberts also spoke of the dangers of disinformation, which are, quote, magnified by social media, which provides a ready channel to instantly spread rumor and false information. Put simply, this defendant has caused enduring damage to public perception of the criminal justice system and has placed officers of the court in harm's way. In the probation report, which we just received this morning, the author, having interviewed the defendant, noted that the defendant sees himself as above the law and won't accept responsibility for his actions. And that's certainly consistent with everything else that we've seen. Now, in a typical case, both the offense conduct and these other exacerbating factors would impact the appropriate sentence. But in this case, we must be respectful of the office of the presidency and mindful of the fact that the defendant will be inaugurated as president in 10 days. Any undischarged portion of the sentence has the potential to interfere with the defendant's performance of the duties of his office. As a practical matter, the most sensible sentence prior to his inauguration is an unconditional discharge. The court has expressed an inclination to do exactly that because, in the court's words, quote, the most viable solution to ensure finality and allow defendant to pursue his appellate options is to proceed to sentence. As you know, in New York, a conditional discharge is authorized by penal law, quote, if the court, having regard to the nature and circumstances of the offense and to the history, character, and condition of the defendant, is of the opinion that neither the public interest nor the ends of justice would be served by a sentence of imprisonment, and that probation supervision is not appropriate. An unconditional discharge is authorized if a conditional discharge is authorized and, quote, if the court is of the opinion that no proper purpose would be served by imposing any condition upon the defendant's release. Because these crimes are felonies, the court must set forth in the record the reasons for its action. The American public has the right to a presidency unencumbered by pending court proceedings or ongoing sentence-related obligations. But imposing this sentence ensures that finality. Sentencing the defendant permits this court to enter judgment, to cement the defendant's status as a convicted felon while he pursues whatever appeals he intends to pursue. And it gives full effect and respect to the jury's verdict while preserving the defendant's ability to govern. People therefore recommend that this court impose a sentence of an unconditional discharge. Thank you.
Thank you. Counsel.
Thank you, Your Honor. I very much disagree with much of what the government just said about this case, about the legitimacy of what happened in this courtroom during the trial, and about President Trump's conduct fighting this case from before it was indicted, to while it was indicted, to the jury's verdict, and even to this day. What the government just said presupposes something that we disagree with very much, which was that this was an appropriate case to be brought. It was not. This case, without a doubt, knowing everything we know about the timing of the investigation, the fact that multiple prosecutors looked at the fact of this case, including prosecutors within the district attorney's office in New York County, and made a decision not to bring charges. As the court knows, shortly after President Trump announced his intention to run for re-election, this case was started for what amounted to a third time, which brings us ultimately to where we are today. A lot of what the government just said presupposes that this case is legally appropriate and that the charges that were brought by the people were consistent with the laws of New York. Again, we very much disagree with that, and as everybody has been noted, because it's true, we certainly intend on appealing that. And it's not, by the way, just counsel and President Trump that feels that way. There's many legal experts that share the same views that I just said, which is that legally this case should not have been brought, both based on the facts that were established at trial and also on the legal basis for which they were brought. But it's also not just the legal experts, not just counsel, and not just President Trump, but the majority of the American people also agree that this case should not have been brought. I mean, the interesting thing about the fact that there was a trial for the first time in our history, a criminal trial during an election season, is that the American voters got a chance to see and decide for themselves whether this is the kind of case that should have been brought. And they decided. And that's why in 10 days, President Trump is going to assume the office of the President of the United States. And certainly we're here for the court to sentence President Trump to an unconditional discharge. And for that, it's a very sad day. It's a sad day for President Trump and his family and friends. But it's also, in counsel's view, a sad day for this country, because this was a case, without a doubt, that was brought by a district attorney who promised that he would go after President Trump if elected, and felt like he had to go through with that promise. And so that's sad. And I hope, and I know that President Trump shares this view, that this will never happen again in this country. And so we certainly understand where we are today. We very much intend on pursuing an appeal of this verdict and what happened during this investigation. And we certainly believe that the only appropriate sentence, if one's to be imposed at all, which we very much believe it shouldn't be, and that the case should be dismissed, is a sentence of unconditional discharge. Thank you.
Thank you. Would your client like to be heard?
Yes, thank you, Your Honor. This has been a very terrible experience. I think it's been a tremendous setback for New York and the New York court system. This is a case that Alvin Bragg did not want to bring. He thought it was, from what I read and from what I hear, inappropriately handled before he got there. A gentleman from a law firm came in and acted as a district attorney, and that gentleman from what I heard, was criminal or almost criminal in what he did. It was very inappropriate. It was somebody involved with my political opponent. Part of the records that we're talking about, they're saying, I just noticed where he said I was falsifying business records. Well, the falsification of business records, as they said, was calling a legal expense in the books where everybody could see them, a legal expense. In other words, that legal fees or legal expense were put down as legal expense by accountants. They weren't put down by me, they were put down by accountants. I didn't call them construction, concrete work, I didn't call them electrical work, I didn't call them anything. They called a legal fee or a legal expense, and for this, I got indicted. It's incredible, actually. Now, if you look, my attorney alluded to it, the top legal scholars and legal pundits in this country, the ones that are quoted all the time on television that are making their views felt and highly respected people, have said, everyone, virtually everyone that I know of, haven't seen any to the contrary, not one, and none of these people are not exactly friends of mine, to put it mildly. But they all said this is a case that should have never been brought. It's an injustice of justice. Very respected Jonathan Turley, Andy McCarthy, Judge David Rifkin, a wonderful man who just passed away, by the way, Greg Jarrett, Ellie Honig from CNN, of all places. CNN said that, Paul Ingratiot, Alan Dershowitz, they all said this is not a case that should be brought. It's not, think about it, legal expenses are down as legal expenses, and I get indicted for business records. Everybody should be so accurate. It's been a political witch hunt. It was done to damage my reputation so that I'd lose the election, and obviously that didn't work. And the people of our country got to see this firsthand because they watched the case in your courtroom. They got to see this firsthand, and then they voted, and I won and got the largest number of votes by far of any Republican candidate in history, and won, as you know, all 7 swing states, won conclusively all 7 swing states, and won the popular vote by millions and millions of votes, and they've been watching your trial. So they understood it. I wasn't allowed to use the lawyer-client privilege or the reliance on counsel. I had a lawyer that made this deal, and he admitted that. And he was also a totally discredited person. We weren't allowed to use the information from the Southern District that totally discredited him. It wasn't allowed to be put in. And that was terrible, unbelievable. And this is a man who's got no standing. He's been disbarred on other matters, unrelated, and he was allowed to talk as though he were George Washington, but he's not George Washington. He shouldn't have been allowed. The Southern District did a book of approximately 28 pages where I've never seen anything like it. They excoriated him. You wouldn't let it be put into evidence. So he was able to testify as a witness, and I think it's a disgrace to the system. I was under a gag order. I'm the first president in history that was under a gag order where I couldn't talk about aspects of the case that are very important. I guess I'm still under, so probably I won't do it now. I assume I'm still under a gag order. But the fact is that I'm totally innocent. I did nothing wrong. They talked about business records, and the business records were extremely accurately counted. I had nothing to do with them. Any of it. That was done by an accountant or a bookkeeper who I think gave very credible testimony and was corroborated by everybody that was asked. And with all that's happening in our country today, with a city that's burning to the ground, one of our largest, most important cities burning to the ground, with wars that are uncontrollably going on, with all of the problems of inflation and attacks on countries and all of the horrible things that are going on, I got indicted over calling a legal expense a legal expense. It was called a legal expense. I just want to say I think it's an embarrassment to New York, and New York has a lot of problems, but this is a great embarrassment. I believe that this and other cases that were brought, as you know, the DOJ is very much involved in this case. That's because that's the political opponent they're talking about. The DOJ is very involved. You have a gentleman sitting right there from the DOJ who was from the DOJ's office. He was also involved with the New York State Attorney General's case. And he went from there to here. He went around and did what he had to do. He got them to move on me. But in the meantime, I won the election in a massive landslide. And the people of this country understand what's gone on. This has been a weaponization of government. They call it lawfare. Never happened to any extent like this, but never happened in our country before. And I'd just like to explain that I was treated very, very unfairly. And I thank you very much.
Thank you, Mr. Trump. Mr. Trump, you appear before this court today to conclude this criminal proceeding by the imposition of sentence. Although I have taken the unusual step of informing you in advance of my inclinations, before imposing sentence, I believe it is important for you, as well as those observing these proceedings, to understand my reasoning for the sentence I am about to impose. The imposition of sentence is one of the most difficult and significant decisions that any criminal court judge is called upon to make. Our legislature sets the parameters for an authorized sentence, but it is a judge that must decide what constitutes a just conclusion to a verdict of guilty. A court is vested with broad discretion in determining what sources or evidence it may consider to arrive at an appropriate sentence. In doing so, the court must consider the facts of the case along with any aggravating or mitigating circumstances. In my time on the bench, I've been called upon to grapple with this weighty responsibility for countless defendants who have been found guilty after trial for an assortment of offenses, ranging from nonviolent Class E felonies to the most heinous of crimes, including homicides, sex trafficking, and child sexual abuse. The task is always difficult and deserving of careful consideration, whether the sentence be an unconditional discharge or incarceration of 25 years to life. However, never before has this court been presented with such a unique and remarkable set of circumstances. Indeed, it can be viewed fairly that this has been a truly extraordinary case. There was unprecedented media attention, public interest, and heightened security involving various agencies. And yet, the trial was a bit of a paradox because once the courtroom doors were closed, the trial itself was no more special, unique, or extraordinary than the other 32 criminal trials that took place in this courthouse at the same exact time. Jury selection was conducted, the same rules of evidence were followed, opening statements were made, witnesses called and cross-examined, evidence presented, summations delivered, the same burden of proof was applied, and a jury made up of ordinary citizens delivered a verdict. And it was all conducted pursuant to the rules of procedure and guided by the law. Of course, part of what made it feel somewhat ordinary was the outstanding work, preparation, and professionalism of the clerks, court officers, court reporters, security personnel, and the entire staff of this building who did their jobs as they would with any other criminal trial. So while one can argue that the trial itself was in many respects somewhat ordinary, the same cannot be said about the circumstances surrounding this sentencing. And that is because of the office you once occupied and which you will soon occupy again. To be sure, it is the legal protections afforded to the office of the President of the United States that are extraordinary, not the occupant of the office. The legal protections, especially within the context of a criminal prosecution, afforded to the office of the President have been laid out by our founders, the Constitution, and most recently interpreted by the United States Supreme Court in the matter of Trump versus the United States, which was decided on July 1st, 2024. As with every other defendant in your position, it is my obligation to consider any and all aggravating and mitigating factors to inform my decision. Some of those aggravating factors have already been articulated in my Sandoval ruling at the start of this trial and by my recent written decisions on December 16th and January 3rd. Thus, they need not be repeated at this time. However, the considerable, indeed, extraordinary legal protections afforded by the Office of the Chief Executive is a factor that overrides all others. To be clear, the protections afforded the Office of the President are not a mitigating factor. They do not reduce the seriousness of the crime or justify its commission in any way. The protections are, however, a legal mandate which, pursuant to the rule of law, this court must respect and follow. However, despite the extraordinary breadth of those protections, one power they do not provide is the power to erase a jury verdict. It is clear from legal precedent, which until July 1st was scarce, that Donald Trump, the ordinary citizen, Donald Trump, the criminal defendant, would not be entitled to such considerable protections. I'm referring to protections that extend well beyond those afforded the average defendant who winds their way through the criminal justice system each day. No, ordinary citizens do not receive those legal protections. It is the Office of the President that bestows those far-reaching protections to the office holder. And it was the citizenry of this nation that recently decided that you should once again receive the benefits of those protections, which include, among other things, the Supremacy Clause and presidential immunity. It is through that lens and that reality that this court must determine a lawful sentence. After careful analysis, in obedience to governing mandates, and pursuant to the rule of law, this court has determined that the only lawful sentence that permits entry of a judgment of conviction without encroaching upon the highest office in the land is an unconditional discharge, which the New York State Legislature has determined is a lawful and permissible sentence for the crime of falsifying business records in the first degree. Therefore, at this time, I impose that sentence to cover all 34 counts. Sir, I wish you Godspeed as you assume your second term in office. Thank you.
And there you have it, those 34-minute proceedings, historic proceedings from Manhattan Supreme Court, in which you saw President-elect Donald Trump formally sentenced to unconditional discharge on those 34 felony counts related to that hush money payment. Again, no prison, no penalties, no fines, no probation, but he is now officially a convicted felon. Let me bring back in NBC's Laura Jarrett, who's joining us now, our senior legal correspondent. And Laura, there are a lot of extraordinary moments throughout the course of this trial for President-elect Trump, many firsts for the United States of America. And here another one. We had not heard Judge Merchan speak. You have, because you've been in court and you watched those proceedings, but the vast majority of Americans have not. We have not heard President-elect Trump speak in court this way before.
Yeah, it's interesting that Judge Merchan decided to make the audio public here, Hallie. As, of course, you will know, we pressed him for the audio, for the video throughout the trial so that America could see a trial of a presidential frontrunner, a former president at that time. Now, of course, President-elect set to be sworn in just 10 days from now. Clearly, Judge Merchan taking his time to explain his reasoning, even though he had given a preview of what the ultimate sentence would be of no penalty. He wanted wanted to make the record clear about how he got to that result and how this is about the office of the presidency instead of the person occupying it. You heard a somber tone. You also heard a measured tone. And even from the president-elect himself, the words that he was saying, obviously quite harsh against the judge and against the process, it says, and the DA, some familiar lines there. But also, he was not ranting in the way that we had heard him outside of court. And so it was interesting just to sort of see how his tone had changed, Hallie. I also just think it's noteworty here. We are some 10 days out, and the judge was making it clear we may be in a different circumstance if he had not been reelected. He didn't say that his sentence would change. He didn't give any sort of preview of that, but he did seem to want to underscore we are in a very different posture than we were when the verdict came down in May. But still, it seemed that the judge, in the interest of justice, in the interest of finality, felt the need to go through with this process. You might be wondering, why do all of this if you weren't going to sentence him to any penalty? What's the point of sort of all of this pomp and circumstance? And I think the judge wants to send a message to people who are going to serve on juries in New York that your work is not for naught, right? The whole point of this still, the justice system still has a purpose. And I think that was part of why the judge went through this entire process today, Hallie.
Laura Jarrett, thank you very much. I know we'll be looking for more from you later on tonight on NBC News Now and, of course, on Nightly News. NBC News legal analyst Danny Savalos is joining us as well. Talk about what's next, Danny, because the president-elect himself has previewed the possibility of an appeal. He can do that, right? But what are the chances?
He will definitely appeal. There's no question in my mind. I mean, even with a sentence of nothing, and that's what this was, a sentence of nothing whatsoever, there are collateral consequences. In other words, other consequences besides incarceration that come from a felony conviction. Now, do they affect this president that much? Maybe not as much as other citizens. He's going to be disabled from owning a firearm. There are all kinds of different things that felons cannot do. So he will certainly appeal. For him, if for no other reason than the symbolic reason that he wants to fight his conviction and get back to 0 convictions if an appellate court looks at this case differently, which it might. Even Justice Merchan acknowledged that we're dealing with brand new case law in the form of the Supreme Court's immunity decision. Who is to say what direction the appellate division might go, and maybe even some federal courts if the defendants can get this appeal somehow into federal court.
Danny Savalos, thank you very much for being with us this morning. This historic morning for President-elect Donald Trump. To recap, he has been sentenced to unconditional discharge on those 34 felony counts related to that hush money payment. The conviction will stand, but he will serve no other time, no fines, no probation, no other penalties there. He is, of course, officially now a convicted felon. As you heard Danny and I talking about just a moment ago, the president-elect's team has pledged to appeal. All of this happening just 10 days before Inauguration Day, when the president-elect will move to the White House for another 4 years in office.
Thanks for watching. Stay updated about breaking news and top stories on the NBC News app or follow us on social media.